PTO, Ken and Stephen. It's all yours, Stephen.
Great, and thank you, Mark and John, for inviting me tonight. And thank you all for all of those of you who are online. We do appreciate you spending some of your Friday evening here with us tonight. And hopefully we've got something of value for you. And as Mark said, we do encourage you to use the Q&A chat box to enter your questions throughout the presentation. I hope this isn't just me going on for the next hour or so. I hope you guys are able to get your questions answered and get something valuable out of the investment in your time tonight. So with that, I'd like to talk a little bit about what I'd like to do tonight. I'd like to start simply by going over some of the resources available for independent and small inventors from the USPTO, whether it be reduced filing fees or other invention assistance programs that we have for your disposal. So that'll be kind of the first half of what I'd like to discuss today. And then I'll follow it up with specifically some of the relief that we've made available to patent applicants as a result of the CARES Act and overall our approach to providing relief to applicants during the COVID-19 situation that we find ourselves in. So those will be the two main focal points for this evening's conversation. And again, I do encourage you to any questions that you may have, even if you want to take things in a slightly different direction. Please use the Q&A chat box, and either myself or Ken will be able to respond to you guys. Just by way of background information, as Mark said, my name is Steve Koziel. I work out of the San Jose office of the U.S. Patent and Trademark Office. We serve the broader West Coast region, the 7 states along the West Coast. So that's Washington, Oregon, California, Nevada, Arizona, Alaska, and Hawaii. So we're one of 4 regional offices of the United States Patent and Trademark Office. And the whole idea of regional offices is to give you guys a connection to the USPTO in your region without having to travel all the way to headquarters in Alexandria, Virginia, just to be able to speak with someone from the USPTO. We're your local resource for questions that you may have, for issues that you may be experiencing, either in filing an application or prosecuting a patent or trademark application. If you don't know who to go to, call or email me. Right, we're your local resource for the USPTO in the state of California. And just so by way of background information on the PTO as a whole and kind of why we're here, we do outreach like this, because we believe that patents, trademarks, and intellectual property, broadly speaking, is vital to the economic health of this country. Right, it's been a very consistent message from our Undersecretary Andre Iancu and Deputy Undersecretary Laura Peter, who you can see in this slide here towards the right. We believe that's fostering reliable, predictable, and a high quality intellectual property environment really is key for the economic growth of this country, and that's why you're here, and that's why we're here as well. And hopefully I'm preaching to the choir with a slide like this, but this attempts to sort of empirically quantify just the criticality of intellectual property to the U.S. economy. Roughly speaking, and I believe these numbers are from 2017, so they may be a little bit out of date. But roughly speaking, intellectual property intensive industries take up about 45.5 million jobs here in the U.S. And of that, that's pushing 40% of U.S. GDP is derived from those IP-intensive industries, and that translates to better worker pay as well, right? For those employees in IP-intensive industries, they see on average about 46% higher wages than folks working in non-IP intensive industries. So that kind of quantifies a little bit of the importance of IP. It's not just fluff. There's real value here, and that's why we're all here tonight, and that's why you're a part of the Irvine Inventors Forum, right? So just very quickly taking a look at what the USPTO does in a given fiscal year. We process roughly 660 plus thousand patent applications in a given year, and of that, just over half of them tend to issue as patents. Likewise for trademarks, we're going to be pushing about 500,000 trademark applications this year, and a little more than north of half of them matriculate to registered trademarks. And we do that with a team that's really geographically distributed all across the United States. But in particular, as I alluded to previously, there are 4 regional offices. So for most folks on this call, right, your local PTO is up in San Jose, but we also have offices in Denver, Dallas, and Detroit that serve those respective regions. And if you're ever on the East Coast, our headquarters is in a suburb of Washington, D.C., out in Alexandria, Virginia. So I'll spend a minute just talking about some of the resources available at our office in San Jose. We have a number of resources that may be of interest to patent applicants. In particular, we have a public search room. This puts the same technology, the same databases that your patent examiner is going to use to search your patent application right at your fingertips, right? And there's only a handful of locations really across the country where you can get this. They're also available at something called the Patent and Trademark Resource Center that I'll talk about a little bit later on. But in addition to providing you with the most state-of-the-art databases for patent searching, we offer training as well. Right? We offer sort of a workshop on how to actually make use of our databases, our search databases. So that's a feature that we offer. Our examiner interview rooms. If you need to have that face-to-face conversation with an examiner, but they're geographically we do have a geographically distributed workforce, right? The odds of your patent examiner being near you are low. So if the reality is, you can either pick up the phone and call them, or you can have a WebEx type conversation like this. And so we offer a facility in our space that allows you to share documents with the examiner, see them face to face, virtually, of course, and have that more robust exchange of information than you normally would have So, as we alluded to before, right, a number of the, we offer a number of training sessions in addition to just the how to search patents. This is everything from IP 101, how to tell what type of intellectual property you have, whether it's a, something that should be kept as a trade secret versus something that should be patented. We have a number of classes every month to that effect. And all the way through more sophisticated international filing strategy classes that kind of help you make an informed business decision about whether or not to pursue patent protection both in the U.S. and abroad, or just in the U.S., or how to optimize your international filing strategy. We don't just focus on those who are currently interacting with the USPTO, right? We invest in K through 12 STEM education as well, kind of planting those seeds in the younger generations, teaching them the importance of IP and trying to encourage people at that level to take an interest in IP and the STEM fields as well. And all of these slides will be available to you. So if you think I'm going a little bit too fast or skipping a few things, I'm just trying to hit the highlights. But these slides will be at your disposal as well. One of the neat things that we've offered ever since we've had these regional offices is the ability to host one-on-one consultations with folks that are thinking about applying for a patent, folks that are in the middle of a patent application process and seem to be stuck, or even folks at the back end of the process who may have their patents and have a few questions maybe about licensing or about IPRs and the PTAB. We have a number of seasoned patent experts on site that are willing to sit down with you and free of charge, of course, and have a one-on-one meeting to discuss your particular situation. Now, the caveat there is going to be that we are not able to provide formal legal advice, right? We can't tell you what you should do. We can tell you a range of options that are available to folks in your situation that we've seen before. So ever since about 3 months ago, when we entered the shelter-in-place world that we're in today, we took those one-on-one meetings virtual. So now anyone within our 7-state region is able to go to our website, uspto.gov/Silicon Valley, and request a one-on-one consultation with a patent expert or with a trademark expert as well. And they will be able to walk you through your particular situation and hopefully find a path that's mutually agreeable for you. These are just some photos of the particular tools that I had talked about before, including the public workstation. And I also alluded to the patent and trademark resource centers. So now I'm going to shift a little bit to some of the resources in Southern California, and unfortunately there is not yet one in Irvine, but there is a few in Southern California. That's hopefully not too far of a drive away. So at the Los Angeles Public Library, at UC Riverside, and at the San Diego Public Library, they maintain the same set of databases that the USPTO does. They may not have quite as robust a training system that we offer. You may be able to take the search training that the USPTO offers and then apply that at the actual databases that these patent and trademark resource centers in your area tend to offer. Another great page that we like to direct people to if they're not sure where to start is uspto.gov/inventors. This is a fantastic one-stop shop for just about any question you can have about getting started. If you're not sure how to go about structuring a patent search, if you're not sure what are the next steps to take in filing for a trademark, or if you're even not sure what type of IP you have, we have a fairly easy to use IP assessment tool here as well that I'll talk about in a few minutes, that just with a few short questions will help you distinguish the various types of IP that you may be sitting on and may not even realize that you have. So a lot of what I've talked about so far has been patent specific, so I don't want to give short shrift to the trademark side of the house. And in particular, the folks at the Trademark Assistance Center really do a good job of fielding questions from the public. The reality in trademarks sometimes is that once you file for a registration, you're approved. Oftentimes you have fraudulent solicitations being sent to you from people claiming to represent the trademark office, and that can be a danger to people, particularly to smaller entities. So anytime you get something that purports to be from the Patent and Trademark Office, specifically referencing a trademark, and you're not sure, is this legitimate? We encourage you to reach out to the Trademark Assistance Center either by email or phone, and they will be able to help you out at any point, really, during the prosecution and particularly after the prosecution of your trademark application. So they're a great resource. Likewise, more broadly than just patents or trademarks, we do offer what's known as an Inventor Assistance Center. This is a team that's staffed by very senior former patent examiners, patent managers, and experienced trademark managers as well. So these are, on average, people with over 20 years of experience in the field who are available to answer, very broad questions such as where do I start, to very detailed questions about the particular nuances of your patent or trademark situation. So keep the Inventors Assistance Center in mind as well for those types of questions that you may have. So I do want to pivot a little bit away from some of the programs that are directly offered by the USPTO to a couple that are supported by the USPTO, but offered in conjunction with a few other resources, and one of them that's been fairly popular is the Patent Pro Bono program. A lot of times, and I mentioned before the ability for one-on-one consultations. a very common outcome is we'll have somebody, a member of the public, come in off the street, ask to meet with a patent expert in our office. They get to talking, and hey, they've really got something here. They've got an idea, and the next piece of advice from the USPTO expert is, well, you should really look into a patent attorney, right? You should, we always recommend working with a patent attorney to help draft your application, file your application, and shepherd it through the Patent and Trademark Office. So great. How much is that going to cost me? Well, it could be, on the low end, 15,000. On the high end, maybe 25,000+, right? And then, that ends the conversation for many people, right? They, we recognize that there are folks that really just, are not able to work with a patent attorney at that level, and that's where the patent pro bono program comes into play, right? So this really is a nationwide program that's administered at the state and local level that takes those folks that may be financially under-resourced and puts them in contact with a patent attorney, a licensed and registered patent attorney that's going to work with them to draft their patent application, file their patent application on their behalf, and help them prosecute that patent application through the USPTO. So there are some income restrictions, right? Not just anybody is able to apply for that. But here in the state of California, regardless of where you are, the program is supported through the USPTO, but administered by the California Lawyers for the Arts. So if you are in a situation, or if you know someone who may find themselves in that situation, we would encourage you to reach out to the California Lawyers for the Arts, apply, and typically the wait time is around 3 or so months from the time that you apply to the time that they're able to process you and connect you with a local attorney that's going to be able to work with you on your patent application. So it's a great service that's out there. We've had many success stories through this, and we encourage you to check that out. In addition to the pro bono program, we offer what's known as a law school clinic program. Very similar idea, right? It takes folks that, for whatever reason, maybe they weren't able to get into the pro bono program, or they just didn't have an attorney in their immediate geographic area that they felt comfortable working with. So kind of in parallel to that, we offer this law school program where basically it's the same idea as the pro bono program, right? You apply to the program, in this case the law school certification program. We make sure that you meet the income-based requirements, and then we match you with a law school student, a current law school student studying IP and patent law, under the guidance of a law school faculty clinic supervisor, and you work with that student to draft your application, file your application, and prosecute your application before the USPTO. And so there are a handful in Southern California. The biggest difference is that the law school certification program is open to trademark applications as well, right? The patent pro bono program that I had talked about a few slides ago is exclusively limited to patent applications. So if there's a number of schools here that either deal with only trademarks or only patents, but but the ones like Thomas Jefferson or San Diego, they accept both the patent and trademark applications through this program. So we encourage you to look into those programs if you think that that you qualify, and take advantage of them. Moving on, one of the interesting things about the USPTO is that it is one of the few, one of the only really user fee funded agencies in the federal government, right? We do not take taxpayer appropriations, right? All of our operating revenue is derived from the fees that our users pay when they file a patent application, when they file a trademark application, and as they prosecute those applications through our office. So that said, if you're at all familiar, you certainly know that there's just about a fee for everything at the office. That said, don't pay more than you have to. And the best way that you can not pay more than you have to is by making sure that you're availing yourselves of the discounts for both small and micro entities. And in particular here, I'm sharing the micro entity status, right? And if you meet the criteria here, and that's typically that you as yourself or as an entity employ fewer than 500 people, are not a named inventor on 4 previously filed applications, or did not assign any 4 or more previous patent applications to someone who falls outside of this microentity status, and you meet the median, don't have a gross income exceeding 3 times the median household income. If you meet those qualifications, then congratulations, you're a microentity, and you're entitled to 75% across the board fee reductions, for your patent application fees, right? So that means that as a microentity, you can file your provisional patent application for under $100, right? You can get to patent pending status for under $100, right? And like I said, that microentity or that small entity status stays with you throughout the life of that patent application. Just one note of caution on that. If at some point during the life of the application that you're prosecuting, you are no longer a microentity status, say you got that first round of investment from a venture capitalist or angel investor, and you were obligated to assign that patent right to them, it is your responsibility to notify the office that you no longer meet the criteria for microentity status listed here, right? So that's not going to happen frequently, but when it does, that is something to keep in mind. Another program that we like to highlight. Again, it matters to some folks, doesn't matter to others. But if speed of examination is paramount to you, we do like to make note of the Track 1 prioritized examination program. This, if you need your patent application to go from a filed application to an issued patent within 1 calendar year or less, the Track 1 program is for you. So basically, either at the time of filing or shortly thereafter, you file a petition to enter this Track 1 accelerated examination program. And once that petition is granted, the USPTO guarantees a final disposition in that patent application within 1 calendar year. Great for some industries, less important for others, but if you need it, it's there. Kind of coming to the end of some of the programs I wanted to highlight, there is there is a patent ombudsman program. I think of this as a way to unstick a patent application that, for whatever reason, has just gotten stuck. Either you've got a particularly recalcitrant examiner that just you're not able to make any progress with them, or it's been 6 months since you've heard from the office and you can't tell what's going on with your application. There is this ombudsman program that can kind of do the sleuthing that will get to the bottom of what's going on with your application and help you unstick those applications that may be stuck. And the neat thing about this is that the patent ombudsman is not in the chain of command of the patent examiner or the patent examiner supervisor, right? This is a kind of a third-party, fresh pair of eyes that's going to take a look at your application and offer constructive advice to the examiner or to the supervisor as appropriate to help you with your case, right? So a lot of times, for whatever reason, patent applicants are hesitant to go directly to their examiner or to go directly to the examiner supervisor out of maybe they fear some type of reprisal. But this is a third party, outside of the chain of command of the examiner that you can go to if you're not comfortable going to your examiner or their supervisor. Now that said, the best person often is your patent examiner to help you unstick those cases. So we do encourage you to build a good relationship with your patent examiner, by giving them a call and talking through issues that you may be having on your cases. So then, that's that. If that for whatever reason doesn't work, or you're not able to get a hold of the examiner, the ombudsman program is available to you guys. I did Ken's telling me I did catch a question on microentity status, and that does apply if you're an individual. Or if you're a company that meets these criteria, right? So whether maybe you're the inventor and you're assigning your invention to a company that you own or co-own with someone, as long as that company meets the criteria here for microentity status. That is going to apply, regardless if you're an individual or a company. It's the criteria that matter. All right. So something that might be of interest to this group in particular. Typically every summer, the USPTO hosts, every summer for at least the past few years, the USPTO has hosted an invention convention. And it's interesting. This year it's going to be August 20th through 22nd, completely online. But it brings together a number of startups and smaller businesses in particular who have had success in the patent process and who have leveraged that success in growing their businesses. So it's not people from the USPTO talking, right? It's the USPTO bringing together entrepreneurs and startups, and basically allowing them to share what's worked well from them, and you get to really hear it from the horse's mouth. They talk about the resources that they've used, that they found particularly helpful. There's a really good panel every year about what I wish I knew, when I was starting out or when I was midway through the process. So that there's some real value there. So we encourage you to check that out. I believe it is free to register for, and there's a link there at the bottom if you're interested in checking out this all virtual event later this August. And so I mentioned this a while ago, but the IP awareness assessment tool. Here's a direct link to it. This is really just more for your reference if you want to download these slides and keep them. But here's a direct link to that IP awareness assessment. And it really it was co-developed by the USPTO and NIST. And in just a few dozen questions, most people are able to get through it in under a half an hour. It really helps you crystallize, what you have that really is, really should be patented. Really is perhaps maybe better kept as a trade secret. Or if you're sitting on a design patent, maybe that you may not realize, right? So it walks you through that process of kind of seeing what you've got and helping you make sure that you've got the appropriate, or you have a plan at least for the appropriate protections based on what you have. And this is just a roll-up quickly of some of the resources that I had highlighted before, kind of a neat one page that you can print out and have at your ready. So before I jump in to the USPTO's response to the COVID situation that we're in, I do want to maybe pause and see if there's any additional questions in the chat that we can take a look at. At the start, I'd mentioned that our current Undersecretary and Director Iancu, really valued the role that intellectual property plays in the economy. And one of the ways that he's sought to bring about change to make sure that there is a balance in the system has been with the patent the Patent Trial and Appeal Board, the PTAB. Over the last 2 years, the director and the chief judge of the PTAB have instituted a number of new standard operating procedures and a number of new trial guides for their judges. And for the public as well, designed to restore more of a balance within the IPR regime at the PTAB. And that is a work in progress, right? That is that's something that we certainly do receive a lot of feedback from the community, from the independent inventor community, regarding the RTR regime, and that is something that we hear, and that is that is something that that maybe had been a bit out of whack for a time, and there could be a variety of factors that contribute to that. But I know that it is the priority of the director to to make sure that every patent that the USPTO issues can be consistently and reliably enforced, and that is the overriding goal, and it's the goal that is behind the the push to clarify our subject matter eligibility guidance in Section 101. It's the push behind the move to restore a balance to the PTAB, and it's an ongoing effort. Right, and we continue to receive feedback, from all different types of entities, large and small, across the country, across fields of endeavor, and strive to create a balanced IP system that overall benefits the economy, benefits the American people, and it benefits the people that are doing the hard work of innovating and inventing in this country, and that's so I think that may address a few of the questions that had come in the chat previously, and I don't see any additional questions at this point. So I'll pivot to a number of steps that the USPTO has taken over the past few months in response to the unprecedented situation that we find ourselves in with respect to COVID-19. So just initially, on the USPTO.gov homepage, there is a COVID-19 response resource center. That's front and center on our page. That is the one-stop shop for a lot of what I'm going to be ticking through in the next few minutes. And there are a number of steps that the office has taken that I'd like to highlight. In particular, there's a novel patent licensing resource that the agency recently created that I'll talk about in a few minutes. There are a number of direct relief actions involving the deferral of certain patent deadlines and patent fees. And there are a number of very specific trademark notices that we've put up as well that I'd like to highlight. So one that I didn't mention yet is the COVID-19 prioritized patent examination pilot program. Which is very interesting. I'd mentioned the Track 1 program that gives you accelerated examination of your patent application for a fee. That same concept of accelerated patent examination is available in the COVID-19 prioritized examination pilot. So if you do have a patent application that is related to either the treatment or potential cure for COVID-19, and you self-certify that the application you're filing is directed towards that type of technology, we will basically move your application to the front of the line, and we're aiming for final disposition of those applications within 6 months from the time of filing. Additionally, as I alluded to earlier, we've seen a number of fraudulent trademark solicitations, and specifically those that are related to COVID-19. So we find that that's important to highlight on this page as well. So again, if something doesn't look right, we're listing some of the more common fraudulent solicitations that we've seen, and we encourage you to come to us, either by calling us or going to this resource center and seeing if the fraudulent or the solicitations that you're receiving are legitimate or match some of the known fraudulent solicitations as well. And certainly, last but not least, there is an international aspect to this as well. Some patent granting agencies across the world have implemented universal delays in fees, or automatic delays in fees and filing deadlines. And for some, it's on a voluntary basis, right? So we've linked to, in particular, the WIPO, the World Intellectual Property Organization's COVID-19 policy tracker that lists country by country exactly what steps, if any, they have taken to provide relief to patent holders and patent filers in this situation. And again, we fully appreciate that this is an evolving situation, and that your needs today may not be your needs 3 months, 6 months, a year from now, right? We really, no one can really say when we get back to normal. So, we want to continue listening to your feedback as well, and so we encourage comments on what type of relief you need to see, or that you think you would benefit from. To send those to COVID comments at uspto.gov, and there's a link to that at the bottom of our resource page here. So before I jump into the Patents for Partnership, which is that licensing platform that I had alluded to, I did notice a quick comment in the chat about provisional patents, and I think that's a great question. So if you'll permit me a slight digression, I'll just talk briefly about provisional patent applications. Just by way, and I apologize if this is old hat for some of you, but just by way of context, when we say we're going to file a patent on something, when you watch Shark Tank and they ask you, do you have a patent on this? What they're really asking is, do you have a non-provisional utility patent on that? Right, that's the patent application that is eventually going to matriculate into an issued patent. The reality is not everyone is at a place where they're ready to file for that non-provisional utility patent application, right? They may need to do some more prototyping. They may not have the funding lined up yet. They may not know if there's enough interest in getting someone to manufacture what they have, or they may still be working out a sales arrangement, right? So, if you're in a position where you've got something that's almost ready to go, but you need a little bit more time, For many folks, the provisional application can be very useful. The provisional application, for those who do qualify for that microentity status that we talked about, again, this is for under $100. You're able to file your provisional application, get that patent pending status, and most importantly, plant your flag in the ground as to the date of your invention. Something that I hadn't mentioned is that the United States, much like most of the world's patent granting agencies, is a first inventor to file country. Right, so it doesn't matter, when you came up with your invention or when you annotated your lab notebook with that last, aha moment that really cemented your invention. No, what matters is when you filed your patent application with the USPTO. Right, so that filing date is absolutely pivotal. And the provisional patent application is the most cost-effective way to get your application in the door, filed with the USPTO, get you that patent pending status. And what it does is it buys you 1 year, right? 1 year from the date that you filed your provisional application to make a decision on whether or not it's appropriate for you to pursue the non-provisional utility patent application, right? It's a little more expensive to file the non-provisional application. You may, in fact, we encourage that you work with an attorney, and there may be other business considerations as well that kind of play into that. So if you're kind of on the fence or you're not sure that you're quite ready to go for the full provisional the full non-provisional application, we do encourage you to look at the provisional application as an alternative to that. Okay, so I'd like to jump to a few more programs that we've just launched. I believe this is less than a month ago now, and one of the interesting ones is this patents for partnerships. So if you follow the patent field, you may have heard that there are certain organizations that are creating so-called patent pools of patents or published applications that are related to the diagnosis or treatment of COVID-19, and so the USPTO's attempt along those lines is what we've called this Patents for Partnership, where basically anyone, whether you're a research university, an independent inventor, or a larger company, can submit their either issued patent or published patent application to the USPTO, claiming that it is, again, directly related to the diagnosis or treatment of COVID-19, and we will list it publicly on our website and make it available for search on this Patents for Partnership website. And the idea is, that you're looking to license this technology, right? This has been particularly attractive to smaller and independent inventors, because if you're a large company, right, you have your own, in-house licensing apparatus, right, and you really don't necessarily need the USPTO for this. But if you're a smaller company and you think you've got something that is directly related to to improving the situation, we encourage you to consider this as a way to kind of broadcast the technology that you have and say, hey, I'm willing to take I'm looking for a license on this, right? And we've seen a number of other agencies kind of sign off on this, everything from the FDA to the CDC. So there's sort of broad government buy-in for a lot of this, and it's fairly easily searchable by by keyword, by inventor, by assignee, or the like, and it's it's a fairly simple form that you fill out to link your patent or your published patent application to this marketplace. You fill it out, you self-certify that it is directly related to, again, the treatment or diagnosis, and someone at the USPTO will verify that hey, this isn't a garage door opener or something like that. It actually is your technology is appropriate for this, and once they do that, it will be available on our Patents for Partnership website here. Okay, getting towards the end of what I'd like to talk about. Let's see. And that's and I alluded to this this before, but I did want to add a few details to the prioritized examination pilot program that I mentioned, and this I'm not going to spend a lot of time on. This is mainly for your reference, so you don't have to go out and actually read the Federal Register notice to figure out what's going on here. But one thing I want to flag is that normally whenever there's a program to accelerate the examination of your application through the USPTO, there's a fee associated with it. For this program, we are waiving the typical fees that we would charge to accelerate the examination of your application, right? So really the requirement here is that hey, you've got something, and it really is directly related to again the diagnosis or treatments of COVID-19. And so we will, again, once we verify that, we will, take your application to the front of the line, and we have an internal goal of 6 months. 6 months from acceptance into the program till a final disposition on that application, and again with no additional fee for those applicants that are at the small or micro entity status. And again, this is just quickly showing you where there's additional information on that program. Again, mainly for your reference, and it'll walk you through all of the criteria, the request for participation in the program as well, and allow you to submit comments on that. And this is just again more for your visual reference than anything. Like most of these, there is a form that you fill out, and most of these are just one-pagers that you list your application number, you list the inventor, the assignee, the title, and then you check the appropriate boxes here. The good news is, and this is just over a week old now, but we set a cap of a little bit over 500 available slots for this program. And there's only been 11 that have gone through so far that have been actually approved for the program. So there's a lot of kind of latent capacity here to make use of this program. So if you're in this area of technology, we do encourage you to pounce on this because there is there's opportunity here. So I'm just pausing to look at the chat briefly, and I'm seeing a question on that's an interesting question. So I'll repeat the question for folks. Is the risk of patent application denial potentially greater using the prioritized examination program? So I think the closest analog is the current Track 1 program that we have. That's an accelerated examination program that the COVID-19 accelerated examination program is modeled after, and what we see in the Track 1 program is that the rates of allowance are actually higher than than we would expect for a typically filed application in that program, right? There's a number of reasons for that. I think in particular the examiner is incentivized to work with the applicants to identify allowable subject matter as soon as possible in the course of prosecution of the application, and that's very much the case for the for the COVID-19 program as well. So I would again we've only had just about a dozen or so applications enter the program, but based on historic analogs of programs like that offer accelerated examination, I would not think that there would be a substantially lower allowance rate. And if anything, again, I would think that the examiner is internally incentivized to find that allowable subject matter and bring that out. So I would think, if anything, it would have a positive effect on the allowance rate. And one additional question that I think is a good one to address in the chat, goes into the idea of the relationship between you as the patent applicant, or you and your attorney as the applicants, and the patent examiner in general. And there's a lot of misconceptions or myths out there that are fairly pervasive, and not just among independent inventors, but even among seasoned attorneys. Right? I've had I've talked to a number of patent attorneys that have told me that they will never contact the patent examiner supervisor, because they are convinced that every patent examiner keeps a list of all of the attorneys that ever even used a negative tone against them, or every perceived slight from an attorney, and then they go on the list. Or it's interesting, right? I'll speak from my experience. I worked as a patent examiner for the better part of a decade, and I spent about 6.5 years managing teams of patent examiners across various technologies in the USPTO. Examiners don't have enough time really to to keep those types of lists. But no, seriously, right? The examiner wants to reach a final disposition in every patent application that crosses their docket as quickly and as efficiently as possible. I can tell you, as an examiner, it's no fun to feel like you're talking past the applicant and the inventor, either because you feel that they don't understand the rejection that you put forth, or that they think they're claiming something that maybe they're not claiming. It's no fun when you're not on the same page as your inventor, right? You as the examiner are there to make the best decision that you can given the information that you have. And it saves the examiner so much time when you are able to get on the phone or get on a WebEx and talk through a particular rejection that maybe doesn't make sense to you, to talk through, examiner, why did you choose this particular piece of prior art? Or, why on earth are you giving me a 101 rejection on this, right? Instead of, typing up your response, sending it off to the examiner and waiting, 3 months at the earliest for the examiner to respond, pick up the phone, right? Pick up the phone, call your examiners, see when they're available for, a half hour to an hour conversation, and hear them out, right? I can tell you that the examiners, more often than not, are very appreciative of that, right? They too would rather take a half an hour to come to more of a consensus with you as the inventor than they would sitting for 2 hours and typing up a 20-page rejection, right? There's a lot of prosecution efficiencies that can be gained through a simple half hour to an hour conversation between the examiner and the applicant and or their attorney, right? So, and that's really part of the relationship building. Especially if you're the type of inventor that's going to file multiple applications over time in that same field of endeavor, right? It's more likely than not that you'll come across that same examiner at some point down the line. Right, so it really behooves you to to have those interactions, not just on paper, but over the phone or through WebEx with your examiner and or with their supervisor, right? And the reality is, right, that there are going to be some examiners who you feel are simply being unreasonable, are simply not following stated USPTO guidelines, are not following a particular Federal Circuit decision or Supreme Court decision or the manual of patent examination procedure, and you've put them on notice and they continue to be obstinate, and in those situations it is appropriate to contact that examiner supervisor. Right, I've been on the receiving end of those calls, and I can tell you that the first thing I do is verify what you're telling me, and if that's true, then then I'm the one that's on the phone with that examiner telling them that they need to redo this action or they need to withdraw this particular rejection, right? So don't be afraid of one, going through your examiner to resolve any issues you may have, and two, if you're not making progress, following that chain of command and talking to the examiner supervisor in those situations as well. And if you're not making any progress on either of those fronts, that's again where that patents ombudsman program comes into play as well, that I referenced a few slides ago. Again, the ombudsman is sort of a third-party person that's going to be able to assist you in those types of situations where either the examiner or their supervisor are non-responsive, or you just don't feel like you're getting a fair shake. Just a few more questions that I'm seeing pop in. And so, the fee discounts that we talked about for small and micro entity status, they do apply throughout the prosecution of a particular patent application, as long as you continue to meet the criteria, right? So whether that's a request for continued examination, or you're filing a continuation, a divisional in part. For each of those, subsequent filings, right, as long as you are continued to be able to self-certify that you meet the criteria for microentity status, you can continue continue applying for those. And that question was directed towards the entity status, and if that applies to subsequent filings. And so yes, it does apply to the life of that patent application and any subsequent applications for which you still apply and qualify for. All right, and the last question that I'm seeing come in, again, referring to back to the PTAB and challenging already issued patents at the USPTO. Again, we are limited statutorily in the way that the PTAB handles patents challenges through the IPR or covered business method review process. And whether it comes to standards of deference or real party and interest, we are limited statutorily in terms of how we can conduct the proceedings. Okay, so I'm going to just briefly fly through these last few slides that I have, so that we can get to any additional Q&A that you guys have had. These are some good questions coming in, so please keep them coming. Just lastly, looking at some of the additional steps that the USPTO has taken since many of us have been in shelter in place. All of our hearings at the PTAB have been moved to virtual hearings. So whether that's AIA trials, ex parte appeals, we've gone 100% virtual, and there is a standard operating procedure for that that we have in place. So that has been very well received so far. We've made a number of public statements as well with both the EPO and the JPO, talking about the importance of putting up a strong international front, and not just recognizing that our applicants don't just come to one particular office, but IP is a global asset, and we've made a number of statements recognizing that importance with the EPO and the JPO as well. And when I first heard about this, I really didn't think it was that big of an issue. But the more and more people I talk to, electronic signatures are of importance to quite a few applicants, right? So the USPTO has waived the requirement for handwritten signatures on a number of patent applications and patent term extensions, particularly in the plant patents. area. This was a topic of concern for a number of those folks who file for plant patent applications. So we have waived a number of the wet signature requirements and replaced them with electronic signatures. And then finally, through the passage of the CARES Act, right, the director of the USPTO was granted the authority to waive certain patent and trademark related filing deadlines and filing fees as well. And the director has exercised that authority a number of times. The most recent was back on May 27th, announcing an extension of certain filing deadlines for patent and trademark filings through the end of the month. And one thing, and I say through the end of the month, so specifically for small and micro entities, a number of these filing deadlines have been waived through July 1st, and interestingly, for larger entities, they have the ability to request relief on a case-by-case basis, right? So again, small and micro entities, are basically as soon as you self-certify that you are requesting a filing deferral or a deadline deferral, it will be automatically granted. But larger entities are subject to a little bit more scrutiny there. And there are corresponding relief efforts underway at the PTAB as well, right? If people need additional time, or they they want to understand better how the PTAB is applying the CARES Act relief. There was an interesting PTAB board-side chat a few weeks ago that kind of walked through that process for those that may be interested. And that extends to trademarks as well. Trademarks is taking it on a case-by-case basis. If people are interested in getting additional deadline extensions, you can request that on a case-by-case basis at both both for regular trademark filings as well as the trademark trial and appeal board. So with that brings me to the end of my prepared material for this evening. Again, a lot of these slides are really more for your reference, so we encourage you to download them, and we'll be sure to send them to Mark and John so that you're able to have access to these and hold on to them. For your disposal. For those who do have additional questions or comments that you'd like me to take back, I'll be available, and we'll be monitoring the chat, the Q&A chat here. So keep your questions coming in, and I'll do my best to get to them in the remaining time that we have this evening. So I see a question come in on if you're a patent applicant, how can you get automatic reminders of say deadlines that are coming up throughout the application process, or automatic notifications of activity that's taking place in your patent application, and there's a relatively new product that the USPTO had released that we've called My USPTO. So this enables you to you register for accounts. We use two-factor authentication for this is strongly encouraged. But you register for your MyUSPTO accounts, and basically the landing page of your account is a dashboard of alerts that you're able to customize. Whether it's recent USPTO news releases or Federal Circuit notices, or whether it's your custom dockets of patent applications and trademark applications, right? You're able to add the patent applications that you're currently prosecuting, that you've recently filed, and keep tabs on them. Keep tabs on the current status through the office. Keep tabs on when certain deadlines may be coming up, or when certain filing fees may be due. It's a great kind of dashboard view of to the time of final disposition of a patent application. I believe it was just a bit under 2 years on average throughout the USPTO. That varies. It varies by technology, right? There are some technology areas where it takes a bit longer than that, and there are some that are substantially shorter than that. But on average, under 2 years is about what it takes from the time you file to the time that you reach that final disposition of your patent application. That is down from nearly double that, roughly a decade ago. The backlog of unexamined patent applications has come down precipitously over the last, really over the last 15 years. And I think we're now at some of the lowest pendency numbers that we've been at really in this century. So it is a process, though, right? It is a negotiation between you and your attorney and your patent examiner. And the reality is that there's often a fairly extensive back and forth that you go through, amending your claims, overcoming the examiner's objections and rejections, and making sure that the claims at the time of issuance are of the appropriate scope that you're entitled to, and are going to be able to withstand any challenges. And that's a negotiation, and it's a negotiation that takes time between you and your patent examiner. So I often tell people that if your application is allowed in your very first response from your patent examiner, then perhaps your claims are overly narrow, and you left some of your invention on the table there, and perhaps there was a more valuable version of the claims that you didn't include. So in a way, you almost want to see the initial response from your examiner as a rejection. That kind of starts the negotiation, and it really pushes you towards a better set of claims eventually. And I don't have the most recent statistics in front of me, but it's over 90% of patent applications initially are rejected, and go through that back and forth, that negotiation between you and your examiner. So hopefully that addresses that issue of patent pendency. Seeing a couple I guess a theme throughout some of the questions relating to the Patent Trial and Appeal Board, and particularly the relationship between them and independent inventors. you know, I've worked very closely with a number of patent trial and appeal board judges, you know, over time. You know, I started my career with a number of PTAB judges. We were examiners together at the time, and now they're judges. And you know, I know that they work diligently in every case that's before them, whether it's from a large entity, a micro entity, an independent inventor, or anything in between. You know, they pride themselves on you know, resolving individual cases on the facts that are in front of them. You know, whether the facts lead them to you know, to upholding the claims in an issued patent, or whether the facts lead them towards you know, towards canceling some of the claims in issued patents. Right? It is a fact dependent job. And you know, they make the best decisions that they can given the fact pattern that's in front of them for every particular case. Now, you know, anything beyond that, you know, is something that's more structural in nature, and is not something that's able to be resolved necessarily at the PTAB level, but perhaps is more appropriate for you know, for you know, legislation, or you know, for congressional intervention, you know, through legislation that tweaks the AIA and the you know, the inter partes review process. But when it comes to the work of the PTAB themselves, you know, I know they take great pride in their work, and you know, they strive to make the best decision that they can with every case that's in front of them. So, and I'm sorry. Whenever I'm pausing, I'm just glancing at what's coming through the chat here. Yeah, there's a question on the interface of the USPTO.gov. You know, it certainly is something that we're aware of. You know, the great thing about USPTO.gov is that it has the answer to just about any question you may have regarding patents, trademarks, and you know, broadly IP within the U.S. But that's also the curse of USPTO.gov is that there's such a wealth of information that we're continuously trying to organize and display that information in a way that's as user friendly as possible. And it's a challenge. We see that, and you know, just over the past 2 years, really, we've revamped the USPTO.gov landing page. And we've tried to create a number of handy both patent and trademark landing pages as well for folks who don't know where to start. And it's a continuous process to refine and make more user accessible all of the information that we have at USPTO.gov. So it's something we're aware of. It's something we continue to work on. You know, we have an entire team in our Office of the Chief Communications Officer that is dedicated to that task. And they're constantly looking for feedback and ways to improve. And I do apologize. It looks like some folks have been having audio issues throughout the presentation, so I do apologize for that. And you know, again, you will have the slides at your disposal, and you're always free to give me a call or to give our office a call for any additional clarification or just for a one-on-one conversation about a particular issue that you may have that you may not want to raise in front of a larger group. Yeah, so interesting, and again, for those who who may be hanging on, I have no more material that I'm here to present. I'm just going to be responding to questions as they come through in the chat. So I certainly don't want to keep folks who may want to get on with their evenings, but I'm happy to stay as long as questions do keep coming through the chat. And so there's an interesting question. About does the USPTO have a so-called internal affairs office, or who's keeping us honest, to make sure that larger companies are not able to exert undue influence on any proceedings before the office. And the USPTO does have an Office of Enrollment and Discipline that monitors these situations. Right, everyone that is registered to practice before the USPTO is sort of maintained by the Office of Enrollment and Discipline and is subject to to the codes of conduct before representing themselves or their clients before the office, and so any type of activity that falls outside of those codes of conduct is something that is investigated by our Office of Enrollment and Discipline, and those disciplinary decisions are made public. It takes a bit of digging, but if you search Office of Enrollment and Discipline, we have that as well. And thank you. Ken is also reminding me that we have an Office of the Inspector General as well. And for those not familiar, the Office of the Inspector General is independent of the USPTO, and they are an oversight authority that reviews all aspects of the USPTO, from our contracting to our hiring practices to our interactions with the public and beyond. So they are an independent investigative body that for lack of a better word, is there to make sure that the USPTO is being consistent in its treatment of its applicants, and is not running afoul of any laws, rules, or regulations by which we are bound. And I believe both regarding how to access the slides, I think both Mark and John have the slides. And I think when you logged into the WebEx, there was an opportunity to download the slides. But if you weren't able to see that, and any of us are more than happy to send the slides your way. Or you see the email right here, Silicon Valley at USPTO. If you shoot that inbox and email, we'd be happy to send the slides your way as well. So I'm not seeing any additional questions. I don't know if we want to turn it over to Mark, perhaps for a few closing remarks. But otherwise, I thank you all for your time this evening. Again, feel free to contact myself or our office, for any questions that you may have, or any clarifications, or just for a one-on-one conversation. We're happy to help, and I appreciate the opportunity to be able to have this chat with you tonight.
Very good. Thank you, Steve, and thank you, Ken, for being here. What a great presentation. A lot of information. Whenever I've contacted USPTO, it's been very friendly and very helpful. Maybe one of the most friendly, helpful organizations to contact that I've ever contacted. So it was great to have you here with us tonight. And for those attending, thank you for attending. Give a shout out to John for arranging our speakers. John Rao, one of our board members, has done a fantastic job this year and previous times as well. And towards that, I'll give a brief reminder that we meet the second Friday of July, which is July 10th, and it should be a complimentary meeting to this one, in that James Yang is going to talk to us about how to navigate the patent system. So it should be very complimentary to this. So again, thank you, Steve, for a great presentation. Thank you, Ken, for your part in administrating this also. We're so grateful for you being here tonight. So with that, we'll close the meeting, and hope to see you all soon virtually and or in person. Good night.
All right. Thank you. Good night.